Hi, this is Attorney Sharp Raleigh, and we're going to discuss about this new memo that came on June 28, 2018, which says updated guidance for referral of cases and issuance of notice to appear in cases involving inadmissible and deportable aliens. That memo seems to be just another memo, but the problem is that this is one of those kind of change of procedure that has been left really kind of unnoticed until people started picking up on it. What people knew, and this has been the rule for a while now, they usually, whenever you are an inadmissible alien, for example, if you commit a crime and you have some major issues, these are priorities of deportation by the USCIS. However, with this new memo, it seems that they have kind of not changed the priorities, but increased the priorities. Now, pretty much everybody is on the line of a deportation or removal proceedings based on that memo. For example, those who are changing status and you get a denial, the USCIS can come back and say, hey, we are going to put you on deportation, and that means issue an NTA. That's kind of scary because it gives us not much room to maneuver. For example, let's say someone files an extension of status on F1 or H1, it gets denied. That person will usually you have a choice, you can quickly kind of file another extension, if possible, of course, not every time, but if possible, you can file something, and that there's some time to do that. Now with this new memo, it seems they won't give us that time, and that's going to be really a problem. Not only they're going to go after cases which has criminal, where people have criminal, some kind of criminal background, but people who also have just simple denials, and that's very, very, very worrisome. And it's going to put a big burden on the courts because the court is already overwhelmed, and now we're going to have this new memo, and I'm putting the link of that memo under this video. And it is the executive order that they call the Executive Order 13768. What it means is basically passing laws without going to Congress, and they pretty much reiterate in there the same things that was there under Obama, but they added that part on the bottom, if you look at it, and where basically any case where an application is denied, it means an alien is removable, because if you're out of status, that means they have a right to put you in deportation. And it used to be they were more lenient because it gives, for example, let's say someone comes on some kind of visa, the visa expires or there's an extension, and then maybe fall in love, marry a US citizen, they have time to file their cases and file an adjustment of status. But with this thing, things are going to change because it won't really give you time. The case will already be in court, and filing an adjustment of status in court is very tricky, and it's time consuming, and it will take a lot of time to be cleared, especially now that we have all those problems coming up with overwhelming courts. So this is kind of a little bit scary. I had a client who called me and asked me if this was real, and I was not even aware of that memo until yesterday when I found this out. And now I can see that yes, there is a chance. For example, if you have an H-1B visa and you get a denial, once you get the denial, you fall out of status, you become deportable, which is the law, but it doesn't even give you time to kind of look for another job or wrap up things to go back home. And that's where the problem starts, because once you're in deportation, you will have to ask for what we call voluntary departure or try to fight your case in court, which is not really healthy. And of course, this is one of those laws which was passed pretty much kind of quietly. It's not a law, it's more that it's not new. It's things that are there, they're just using it in a different fashion. And that's the part which is scaring a lot of people. And we are going to kind of wait and see now how this is going to be applied, because implementation of it is going to require some kind of timing. I think within 30 days from that memo, they will have to implement this. And we will see how the USCIS is reacting to denials. So for example, let's say you come and on a visitor visa, you're changing status to student visa, and you get a denial, you automatically will not really have time to do much. They will issue an NTA, and you will have to go and fight your case in court, which is a lot more difficult and a lot more heavy. So things are going to get really hectic. They're already getting hectic. I don't know what word to use really, but it's get ready for a lot of more stress. So if you have problems with your immigration, just make sure that you get the work done properly. Even simple applications now, I recommend you hire a lawyer to do it. Although before I was saying it's no need to have a lawyer, because if you get a denial, even with a lawyer you can get a denial. That's no question about it. But you have a better chance of getting an approval. And if you need help from our law firm, just give us a call at 510-742-5887. 510-742-5887, and check our website attorneyonair.com or piralilaw.com. The website also is down. Please subscribe to our channel for any updates. And if you, again, anything I'm telling you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Thank you.